Meanwhile, pressure is only mounting on former Supreme Court Judge AK Ganguly, accused of sexual harassment after writing to the Prime Minister and the President demanding AK Ganguly's removal from West Bengal Human Rights Commission. In fact, the Chief of Human Rights Commission's post, Additional Solicitor General Indira Jaising, has now released the excerpts of the victim's affidavit, which clearly indicate that the act of sexual harassment was committed and thereby completely thrashing AK Ganguly's weak defense.
This was an extremely unprecedented step for the Supreme Court to take. That a committee of 3 judges, 2 of them are incumbent Chief Justices, Justice Lodha and Justice Dattu, and Justice Ranjana Desai, one of the women judges of the Supreme Court. I think the court has done this because they were very concerned about the credibility of the court as an institution, the Supreme Court as an institution. Now, as soon as the report was put up on the website of the Supreme Court of India, I would have expected Justice Ganguly to resign. But he has gone on record to say that he will not resign and that we can do what we want to do, but he will not resign. Now, it is in these circumstances that I did decide to write a letter to the Prime Minister of India, and all that I have said in my letter is that due process of law must be set in motion.
Meenakshi is joining us for more. Meenakshi, Additional Solicitor General has completely put the facts on the table. The victim's affidavit is now in public domain. Despite this, there seems to be an absurd amount of obstinance on part of Justice Ganguly. What is expected?
Well, yes, we have heard Indira Jaising not just today, but ever since the entire controversy broke out. You will recall how on earlier occasions as well, she was demanding Justice Ganguly to step aside. And what is very interesting is the fact that when the contents of the fact-finding committee constituted by the Supreme Court, comprising 3 sitting judges, Honorable Justice Dattu, Justice Ranjana Desai, and another sitting judge of the Supreme Court, when they were seized of the matter and the information had not yet percolated down into the public domain, before that, she was reasonably certain that until and unless the Supreme Court was fairly sure of the facts, it would not have gone ahead and released or revealed the name of the judge. That was a very significant moment when the name of the judge was revealed by the Supreme Court committee. You'll recall before the statement of the Chief Justice had been published in the Supreme Court website. That was the second turning point of this particular case. And thereafter, what we have seen is that Justice Ganguly continues to maintain a very unyielding position on this. Clearly, we've seen him very angry and enraged at the media reports and clearly stating that he will not step aside. On other occasions, he has said that he does not want to be disturbed. And today, what is very significant is how Indira Jaising has been, she is a sitting Additional Solicitor General. That is huge given the fact that she is one of the premier law officers of the government of India in the Supreme Court. And then we have her going on record and really urging the Prime Minister by way of a letter and thereafter clearly stating the position that she has taken on this particular aspect and clearly stating that to uphold institutional integrity, it should be, the onus should be on Justice Ganguly to step aside. But
Meenakshi, I'll come back to you. Let's hear out Indira Jaising's statement that she made earlier.
There is a procedure prescribed in law for the removal of judges of the human rights bodies all over the country. And my only demand is that this procedure should be set in motion. Now, the procedure is that the central government has to request the President of India to make a reference to the Supreme Court itself. And this reference is made with articles of charge. Now, of course, the charge in this case would have to be that he has indulged in conduct of a verbal and non-verbal nature of a sexual nature. And then the details of this conduct will be mentioned. After that, it is up to the Supreme Court of India to conduct an inquiry, giving him a full opportunity to be heard. And then they will come to the conclusion whether an act of misconduct has been committed or not. Please understand, this is very different from a criminal procedure. this is a procedure for removal of a person. It's all there in the Protection of Human Rights Act of 1993. I think the reason is because the girl has exercised a lot of restraint, and she, as you know, in November, she did not even put her statement in, she did not mention his name, okay? And she has been silent. And she has been hesitant about talking. Now, when this happens, actually her side of the story is not yet known, right? It's known only to this committee of 3 judges who put this statement out. Now, in that situation, I think he's very adamant because he thinks that her part of the story will never be made available to the public. So, her silence is what is making him bolder, I think. This is my personal opinion.
ये भी जरूरी है कि अभी कमिटी भी जो फाइंड आउट किया है कि इम्प्रॉपर बिहेवियर था जस्टिस का, तो ये एक क्राइम है। तो क्यों एफआईआर फाइल करने में वो ऐसा फाइंडिंग करने वाला बंदा आज भी एक कॉन्स्टिट्यूशनल पोजीशन में बैठा है? ये हमारी पूरी देश की जनता के सामने एक बहुत बड़ा चुनौती है। हमें हमारे मुंह पे थप्पड़ मारने का समान है वो, क्योंकि ये क्राइम करने वाला व्यक्ति कॉन्स्टिट्यूशनल पद पे बैठी है।